In the state of California, you can get a restraining order even if there is no physical violence. But how far does that go? Can someone get a restraining order just based on snooping? In this video, I'm going to be answering that question and also helping you avoid a huge pitfall that oftentimes people, especially when they are representing themselves on the petitioner side and on the respondent side, are often tempted to make so that you can avoid making that fatal mistake at your hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I am also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to win your restraining order hearing, especially if you are representing yourself. So if that's something that you're interested in, you can get your free first class in the course via the link down below. Okay, so let's jump right in. In domestic violence cases, snooping can come about in a few situations. Number one is the petitioner gets a temporary restraining order forcing the respondent to move out, potentially without getting his or her stuff from the house, right? So your computer is there, iPad, everything is still at the house and potentially accessible by the other party. It can also come about, number two, sometimes it comes about earlier in the relationship. One party snoops through the other party's messages, maybe because they are irrationally jealous, maybe because they are rationally jealous and there is cheating. But either way, when snooping, you might find some really good dirt on the other person, right? That you think, I want to bring this to the court's attention. And I've seen this happen with so many people who call me for a strategy session on the restraining orders, clients of mine, where they submit to me the evidence that they want to use, but I see that there's something off. I see that if it's an iPhone, the text messages that they sent are the gray ones, and the ones that the other party sent are the blue ones, meaning that somehow they got them from the other party's device, or maybe they found really damning pictures in the other party's phone. And sometimes the petitioner will try to use as evidence emails against the respondent, but there's no way that the petitioner should have access to those emails. They weren't sent to the petitioner, and they are from the respondent's email address. And the question always is, well, can I use it? Because yeah, sure, I did something wrong. Maybe I shouldn't have snooped. But look, there's some really bad stuff in these emails, in this evidence. Okay, in the state of California, you can get a domestic violence restraining order against someone based on them snooping if it disturbed your peace. So disturbing your peace means that it destroyed your mental well-being, basically. So it made you very distraught, very upset. Of course, it is subjective, like a lot of things in law, and it's going to depend upon what the person asking for the restraining order says, but that is a basis for a restraining order. So if you, as the respondent, want to trot out evidence that you got because you were snooping, that you think shows the petitioner in a bad light, you think is good for you, the problem with doing that is that the judge can potentially agree with you and not believe the petitioner. But if you snooped, you access personal information, and it caused a petitioner to feel like their emotional or mental state is destroyed, then the restraining order could be granted on that basis. And so rather than submitting that evidence that you think shows that the petitioner is lying, that you obtained by snooping, you might be better off just using what evidence is available to you without the snooping. It might just be your testimony, because that will probably give you a better shot than submitting something that you found and you couldn't have found any other way besides snooping. And you are going to be asked, your own lawyer will have to ask you before you submit any evidence to the court, what is this document? How do you know that it is this document? Where did it come from? They have to establish all that. It's called foundation. And you might be thinking, yeah, but I'm just going to use these documents in court. I'm not trying to show them publicly. Well, there are multiple California appellate court decisions where one party submitted to the court evidence that they only could have gotten by snooping through the other party's personal messages. And the appellate court still found that if the other party's peace was disturbed because of this snooping, then that was sufficient for a restraining order. Basically, making this personal information, this personal private information public and causing the other person distress can be enough to get a restraining order. Now, if you are the respondent and the petitioner attaches documents to their petition, or they show documents in court that they only could have obtained by snooping through your personal messages, then if you are distressed by that, if you feel like your emotional sense of calm was destroyed by that, then you should file your own restraining order. The fact that those documents were court exhibits, that they were brought up in the context of court, doesn't make it any better than posting it on the internet. Because court proceedings are public, and of course you can be distressed thinking that something really personal to you is posted on the internet. You may be thinking, yeah, but they gave me their password a long time ago, or I set up the email account for them in the first place. It does not necessarily matter. Because of this subjective standard, did you destroy their emotional well-being? So this applies to snooping, but I would also caution anyone, especially a respondent, from trying to use any sexually explicit material in court, because doing that, even if it was consensually obtained, could potentially on its own be enough for the judge to say that if the petitioner testifies that they are distressed by this, which most people probably would be, then that's enough for them to get a restraining order. So maybe you thought, well, I have a sex tape from the day after she says that I abused her that shows that she doesn't have any marks on her. I would be very, very careful with using that. Perhaps you can have, if she says that it was marks on her neck and you can just zoom in on the neck and take a screenshot, that would probably be a lot better than attempting to show the video to the judge and show this video in an open courtroom. I hope that you found this video helpful. Again, if you do have a restraining order in California, you can keep scrolling through YouTube hoping to find the answers, or you can get them delivered to you on a silver platter, which is exactly what I do in the course, because with restraining orders, you typically don't have a lot of time and you don't know what you don't know. So it's much easier to learn anything new when someone tells you, here's exactly what you need to learn, and now I'm going to teach it to you. If you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.